Welcome, everyone. We'll give a few more seconds for people to hop in. About 10 more seconds before we get started. Give people a chance to log on. All right. Good afternoon and welcome to the Indiana Institute's webinar of Legal Basics for Youth Serving Organizations, and this is part one. My name is Whitney Johnson and I am the SYPI Project Manager. Thank you for joining us for today's presentation. We are grateful to have a chance to connect as a community of Indiana youth workers who remain committed to meeting the needs of our youth and children. For those of you who are not familiar with IYI, our mission is to improve the lives of all Indiana children by strengthening and connecting the people, organizations, and communities that are focused on kids and youth. Listed here, you can see our vision that drives the work we do for Indiana youth. Before we begin, I'd like to share a few pointers that will help you engage with today's webinar. For any technical support issues, use the chat feature to send a message and I will assist you. Use this feature to converse with the group as well. We also encourage you to ask questions, so please use that Q&A feature for any that you may have, and we will get to as many as possible. Feel free to also upvote great questions to the top. Later today, you will receive an email with a link to complete an evaluation of this webinar. Please take a few minutes to let us know your thoughts about today's presentation. And if you don't receive the evaluation email, check your junk email, as it may have been directed there. Once you complete the evaluation, you will be redirected to your certificate of participation. Like all of IYI's webinars, today's webinar will be posted on our website if you'd like to revisit a portion later or share the opportunity to listen in with partners. All right, it is now my pleasure to turn it over to our speakers for today. Feel free to hop on, team.
Thank you, Whitney. My name is Joe Miller, and we're very, very grateful today to be with you, and we're grateful to Indiana Youth Institute for a long partnership. My colleagues and I, I'll introduce you to my colleagues here in a moment. We are all with the law firm of Faegre, Drinker, Biddle, and Reith, which some of you may know from years gone by as either Faegre, Baker, Daniels, or if you've been in the field for a long time, Baker and Daniels. We have been working with Indiana Youth Institute essentially since its beginning in the 1990s, and all three of us who are with you today have had a long affiliation with the nonprofit practice at Faegre Drinker generally, and with IYI specifically. So with that, I'm going to give you just a brief introduction to my colleagues and me. I'll tell you a little bit about the format of today's presentation, and then we'll be off and running. As I mentioned, my name is Joe Miller. I'm a partner at Faegre Drinker. I lead the nonprofit organizations practice for the firm. And in that capacity, I do quite a bit of work with nonprofit organizations of all kinds, from grant-making organizations to colleges and universities to programs serving charities, and in particular, quite a few youth-serving institutions. And I've been doing this work for about 30 years. So it's been my great privilege to do that. And I'm really grateful to be here with you today. I'm particularly excited that joining me today are my colleagues, Heather Moore and Jane Dahl-Wilson. You'll be hearing from them a little bit later on in the presentation. Heather is counsel in our nonprofit organizations practice. Heather advises nonprofits on a range of legal challenges. She addresses their comprehensive needs on issues related to formation, governance, ongoing compliance, general tax advice, and preparing related documents and policies. She regularly advises colleges and universities, fraternities and sororities, private foundations and other grant makers, community foundations, charities, and many other organizations who are exempt from federal and state income tax. Heather regularly provides advice also regarding issues that relate to the management and modification of institutional funds. Heather has her bachelor's degree from Wheaton College and her law degree from Indiana University McKinney School of Law. Jane Dahl Wilson is a partner in our business litigation practice and interacts regularly in that capacity with the nonprofit organizations. Jane is a multifaceted business litigator and an appellate advocate. She helps clients navigate their most difficult legal problems. She represents clients in complex litigation, including all manner of contract disputes, class actions, tort claims, insurance liquidation proceedings, and employment matters. And in addition to her conflict resolution and trial work, she's regularly involved with briefing and arguments on appeal. Jane also regularly advises national fraternities and sororities. She works with Heather quite a lot in that regard, and she does work in that area on dispute resolution and compliance matters, internal governance, membership discipline, and risk management. And the last of those topics, I think, will be a particular focus for Jane today. Jane has her bachelor's degree from Hanover College and her law degree from Notre Dame Law School. So again, I'm very, very pleased to have Heather and Jane with us today. And if we could move to the next slide, Whitney. We're going to move in. We'll go maybe one more slide. And even one more beyond that, I think. Thank you. Yes, perfect. We're going to start with a bit of an overview of what we call the legal landscape for youth serving organizations. This is just sort of a level set to remind ourselves of the structural considerations for most youth serving organizations and the federal and state laws that that apply in light of those structural considerations. Heather and I will be talking to you about those issues. And then the second part of today's discussion will be led by Heather and Jane, and that will address risk management and mitigation issues. And so with that, we're going to move to the next slide. And I'm going to offer just a few overview thoughts regarding the legal landscape for youth serving organizations. As this slide indicates, most youth serving organizations in Indiana, nearly all of them, I suspect, are formed as nonprofit corporations. That is a state law designation. It means that that those organizations are governed by the Indiana Nonprofit Corporations Act of 1991. We'll talk in a minute too about what federal tax implications there are, but at the state level, most of you are nonprofit corporations and governed by this statute accordingly. This may be sort of an obvious point, but it's helpful to underscore it because it really drives so many other legal issues that we'll be talking about today. No one owns, and I'm using the air quotes here, no one owns a nonprofit corporations. There are no shareholders or other individuals or companies who have a financial ownership in a nonprofit corporation. Rather, nonprofit corporations serve the public interest. They are accountable to the public. And from a legal perspective, instead of being owned by shareholders and then shareholders who elect a board of directors, which is what happens in the for-profit context, nonprofit corporations are in fact also governed by a board of directors, but those boards in the nonprofit context are either elected by members, if a nonprofit corporation has members, or they elect themselves essentially as a self-perpetuating board, or there is some sort of other authority source like third-party nonprofits and other organizations who have appointment powers to the board of directors. In the case of a membership corporation, and that might describe several of you, if you have legal corporate members, there will typically be annual and maybe even more frequent meetings of those members. And at the annual meeting, there would be an election of the members of the board of directors of the nonprofit corporation. And if you do have a corporate membership structure, it's important to know that members have certain rights under the Indiana Nonprofit Corporations Act, including the right to approve amendments to the Articles of Incorporation, as we mentioned a moment ago, the right to elect directors, and also the right to hold essentially a veto power, if you will, by the right to approve certain key actions and decisions like the proposed merger of a corporation or the transfer of substantially all of the assets of the corporation. So we'll move to the next slide. I mentioned to you a moment ago that while it's true under state law that most youth serving organizations are nonprofit corporations, and that describes them at the state level, most of these organizations are also tax exempt from federal income tax under Code Section 501c3. That's 501c3 of the Internal Revenue Code. So it's important to know that those are not sort of either or statuses. You're a nonprofit corporation under Indiana law, and most of you are also exempt from federal income tax under Section 501c3. That's a tax status rather than a sort of legal entity status. What's important about Code Section 501c3? Well, of course, as many of you understand, that allows an organization not only to not have to pay federal income tax on the net revenue that comes in each year, but it also offers the opportunity to raise certain kinds of funds in ways that are not available to organizations who are not exempt under Section 501c3. It allows you to access funds from philanthropy. It allows you to offer tax-deductible treatment for charitable contributions that are made by both individuals and corporations to your organization. So 501c3 status is really, really helpful. It comes with a lot of associated requirements, which we'll go over here shortly. But I wanted, before we go into the sort of the key requirements of 501c3, I want to also mention that there's sort of a level down below 501c3 that's important to understand. When an organization is exempt under 501c3, it is also either a private foundation or a public charity. You're going to be one of those two if you're a Section 501c3 organization. And again, this is in addition to being a 501c3, not instead of. Private foundations typically are organizations that are funded by either one or a very few sources. Think families, companies who establish tax-exempt organizations, and they typically do grant making, not always, but typically do grant making. On the other hand, there's a sort of a subcategory in 501c3 of public charities. And it's advantageous to be a public charity because there are certain sets of rules that apply to private foundations that don't apply to public charities. And so it's important to understand how an organization that is a 501c3 becomes a public charity and stays a public charity. And as noted here in the second bullet on this slide, there are several different public charity classifications. The most common, I suspect, is publicly supported charities under this code section 170B1A6. That reflects the fact that an organization is very broadly financially supported. It has many, many different financial contributors. It is not necessarily accountable to only one or a couple of contributors, but instead a number of them. Think a United Way organization or a Red Cross organization. The second of these classifications, code section 509A2, is also a public support designation. The main difference between that and what I just described is that 509A2 organizations generally are operated on the back of fee-for-service payments. And so they typically charge a fee in connection with the service that they perform. And they typically are funded primarily from that source rather than from donation sources, which is true of that first category. And then finally, we have code section 509A3 supporting organizations. That category refers to an organization that is organized and operated exclusively to support one or more other public charities that themselves meet one of the public support tests that I just described. And so IYI itself is a good example of a supporting organization. It has that relationship to several other publicly supported organizations. So it's really important, as I mentioned, to be aware not just of whether an organization is a 501c3, but it's very important to understand what your organization is in terms of whether it's a public charity or a private foundation. I suspect that almost all of you are public charities. And then it's important to understand how you get your public charity status, whether it's through one of these public support tests that I described, whether it's because you're a supporting organization, because that in turn is going to drive some of your allowable activities, some activities that might be restricted for you, and particularly the way in which you go about raising funds. The public support test really has an impact on how much you can raise from any one particular source. And so it's really important to understand that as you go about seeking funds from philanthropy and from individual sources. We'll go to the next slide. Regardless of a public charity status or a private foundation status, every Section 501c3 organization is required to file an annual tax return that is publicly available. That's Form 990 for public charities. It's Form 990-PF for private foundations. And as noted here, if you fail to file that return and you fail to do so for 3 consecutive years, the IRS will actually automatically revoke the 501c3 status of your organization. So it's really important to keep up with that. Those are typically due on the 15th day of the 5th month following the end of your tax year. So if you're a calendar year organization, your 990 would be due on May 15th of the following year. There's an automatic extension available so that you could push it out to November 15th, and that's true for many organizations. Just a note here about one other type, or actually 2 other types of tax exemption. We've been talking up to this point about exemption from federal income tax, but most C3 organizations are also going to be eligible for exemption from the payment of Indiana sales tax, the collection and payment of Indiana sales tax in connection with its activities, and exempt from the payment of property tax on real and personal property that it owns. But those exemptions require very specific applications, and we've got those listed there. Form NP20A for sales tax exemption, and property tax exemptions are actually filed with local tax assessors through Form 136. And then the final note on that slide indicates that after you have been deemed exempt by the Indiana Department of Revenue, you now have an every 5 years filing requirement. It used to be annual. It's now every 5 years. And which of those 5 years it is depends on, believe it or not, I think it's the last 2 digits of your federal employer ID number. So it's a pretty bare bones reporting regime at the state level. We'll move to the next slide. And then, just as I alluded to earlier, 501c3 status comes with not just great advantages, which we've outlined and which you undoubtedly know about, but it really is important to know that it comes with a number of very important restrictions and prohibitions. And it's beyond the scope of today's webinar to really go in depth into those, but it's really important to just mention a couple that are at the very core of 501c3 status. The most important of the restrictions on C3s is the prohibition on what's called private annulment or private benefit. Those are sort of 2 variations of the same concept, but it basically refers to what I mentioned at the outset, which is that nobody financially owns a tax-exempt organization or a nonprofit corporation. It is accountable to the public. It is held essentially as a public trust, if you will. And so the IRS and state regulators will always be concerned to make sure that the operations of a 501c3 are occurring in a fashion that makes sure that no inappropriate private benefit is flowing to an individual or a company, say an employee or a contractor of the organization. Now, that doesn't mean that you all, as members of staff of 501c3s, can't get paid for your efforts. In fact, you can, but that compensation needs to be reasonable and necessary according to the IRS. And so in assessing compensation and establishing compensation, particularly that for executive staff, it's really important to follow guidance that the IRS uses, which actually comes from Treasury regulations under statute, designed to give you a presumption that compensation is reasonable. And so outlined here on this slide is the very sort of macro description of a framework that will allow you to ensure that your compensation is deemed, at least presumptively, to be reasonable. And there are essentially three prongs to that process when setting executive compensation. One is that the individuals involved in the setting of that compensation need to be independent. That is, the person whose compensation is at issue should not be participating in that process. Neither should anyone who is accountable to that person in the reporting structure of the organization. So that's the composition of the group that makes the decision. And then the second prong is that that group needs to be relying on appropriate data that establishes the reasonableness of the compensation. And the way to go about doing that is to obtain comparability data. And so you'll probably be familiar with the fact that 990s report, among other things, compensation for executives. That information is freely available through GuideStar. And so most of the time, the way that comp committees will go about obtaining compensation data, comparability data, is by looking to peer organizations on their 990s. And then the third prong is that whatever decision is made needs to be documented in the minutes of the proceedings of that committee contemporaneously, that is, at or near the time of the decision. And so minutes should be used, and those minutes should be approved at the next meeting of that committee. And then you'll fulfill the rebuttable presumption process that is established under federal treasury regulations that will allow you to establish the reasonableness of compensation. So with that, we're going to move to the next slide, and I'm going to hand off to Heather, who's going to move into some governance topics for us.
Hi, everyone. It's good to be with you today. Yeah, we're going to transition into looking at some governance items specific to running nonprofit corporations. As Joe talked about, we're talking about nonprofit corporations subject to the Indiana Nonprofit Corporations Act. For the most part, that will be what we focus on today and what I think most of your organizations are. So under the Nonprofit Corporations Act, the board of directors is the primary decision maker for the organization. They're the fiduciaries of the organization, and they're the ones who are charged with making the decisions on behalf of the organization. One thing that's just helpful to keep in mind is that the statute requires a minimum of 3 directors. So if you have a smaller board and somebody resigns or somebody rolls off, just making sure that that you maintain 3 directors. It's an Indiana requirement. It's also just a best practice that the IRS likes to see, that there's some broad representation on the board and not the organization isn't controlled by 1 or 2 people. The board should, because of the fiduciaries for the organization, the primary decision makers, they obviously need to stay abreast of the activities and finances of the organization. So the board needs to actually meet and keep minutes of those meetings. One thing that's helpful to keep in mind, and I'm sure in COVID and post-COVID, most of your organizations, if they didn't before, have moved towards maybe some meetings remotely, and that is permissible under Indiana law as long as directors can simultaneously hear one another. So meetings via Zoom or Teams or other platforms, or even if it's just like telephonic participation, but you can hear one another, that will work. And then one issue that comes up from time to time is how can the board act outside of a meeting? So if you're not going to have a meeting, but there's some item that needs to be addressed by the board, under Indiana law, the board can act by written consent outside of a meeting, but because notice is not provided of such action, those types of action by written consent must be unanimous. So this often comes up in the context of like, well, we just want to hold an email vote to approve something. And so the nonprofit corporation statute doesn't specifically address email votes. What it does address is written consents. And like I said, written consents have to be unanimous. Indiana has adopted the Uniform Electronic Transactions Act, which permits most actions, which require a signature, as a written consent does, to be done electronically. So action by written consent can be accomplished over email. My personal preference is probably to email out the written consent, have the directors sign, scan their signature, and send it back to you. You can also just do it in email. I typically, for purposes of the records of the organization and for verifying it, like something more than just a like yes response. I typically like to maybe put the resolution in the body of an email saying, this is specific action that we're approving. have the directors sign their name electronically, which can just be like typing their signature works, but having them sign their name and date it, and then keep those written consents, whether they're scanned copies, original copies, or the emails in your records, because those need to be kept with the minutes because it is official action of the board. You do want to make sure you're maintaining the minutes, that you're keeping them. They don't have to be overly detailed, but you want to make sure that you document that there was a quorum, who was in attendance, and any key items that the board addressed. Excuse me. My kids have given me their illness. If you're ever audited or anything, it's really helpful if you have the minutes. Excuse me, one second. Part 6 to the Form 990 tracks a series of governance questions. I really am fine. And I think it's helpful for directors to be aware of Part 6 of the 990. None of these are legal requirements. It's not like the IRS can revoke your exemption, but it asks things like, do you have a conflict of interest policy? Do you have a whistleblower policy? Do you maintain minutes? And again, they're not legally required, but it's the best practices, and the IRS is looking at that. So I think it's helpful for the board to sort of be aware of the responses to Part 6 and make sure that you're able to answer affirmatively or however you think the IRS is looking for. So, if you have a conflict of interest policy, able to answer yes, or things like that. I think those are kind of like a nice baseline to look at for policies and procedures that the organization should have in place. And again, that's Part 6 of the Form 990 for public charities that file the 990. Also for public charities that file the full Form 990. I imagine most of your organizations probably do, but some small organizations may not be required to file the full Form 990. Okay, next slide. Fiduciary duties of directors. Again, like I said, the directors are the primary decision-making body, and with that comes fiduciary duties to the organization. Joe spent a little bit of time talking about members, and members do have certain rights, but I think it's helpful to keep in mind that members are not fiduciaries. Like they may have certain rights, but they aren't the primary decision makers for the organization. So they're distinguishable from directors who do have fiduciary duties to the organization. And so sometimes people ask, like, what does it mean to have a fiduciary duty? It's kind of broken down into 3 categories: duty of care, duty of loyalty, and duty of obedience. Duty of care requires directors to act in good faith and that they discharge their duties with care, like a reasonable person would under similar circumstances. So I think of this like you bring your skills and what you know to the board, and you carry that out with reasonable care. So if you're an accountant and you sit on a board, making sure you're paying special attention to the finances of the organization, or whatever skills it is, that you're using those skills to act in good faith and carrying out your duties for the organization. Duty of loyalty, and we'll get to how this duty of loyalty plays out a little bit more on the next slide, but requires that directors exercise and act to further the interest of the organization, and not in terms of any personal interest or interest of any family member or entity or an organization that they own. So again, when you're sitting in that board meeting, you're acting and you're taking actions that are in the best interest of the organization and not sort of any private interest that you have. And duty of obedience is to be faithful to the mission of the organization and ensuring that the organization acts in accordance with its governing documents and applicable laws and regulations. So being aware of what the bylaws say, how action will be taken, being aware of what the organization told the IRS it was going to do in its 1023, and making sure that you're staying consistent with what you told the IRS you would do. So just general awareness of the organization's purpose, its mission, what its governing documents say, and making sure you're acting accordingly. All right, next slide. Consistent with fiduciary duties, this is zooming in specifically on the duty of loyalty. I think this is where we probably get the most questions. And again, like I said, in that Part 6 of the 990, one of the questions is asked is, do you have a conflict of interest policy? This is also asked when you apply for exemption on the 1023. It's not a requirement that you do, but heavily frowned upon by the IRS if you do not have a conflict of interest policy. So my guess is that almost all, if not all, of your organizations do have one. And if you don't, I would recommend that you do. A lot of times we will actually embed it in the bylaws of the organization, just so it's really obvious and everyone knows where to look for it. But you can also have a standalone policy. So under that policy, and they can take different forms, the IRS has some model ones, but generally all of them should provide that a director or officer shouldn't participate in a decision in which they have a financial interest or potential financial interest. And I think one caveat here that's helpful to keep in mind, so like even if it ends up being in the best interest of the organization, so if you have a board member who has a brother and that brother owns a cleaning service that's going to provide services to the organization, it's going to clean your facility, and it's going to result in significant savings to the organization. That is great, and that can be in the best interest of the organization. But that director who's related to that family member who's going to provide the services should nonetheless notify the board of the conflict of interest and shouldn't participate in the decision to hire them to avoid acting on a conflict of interest. One other issue where it comes up sometimes is, especially in communities where it seems like there are some key people who serve on multiple boards and are sort of everywhere in the community, which is common. If you serve on multiple boards, then there are competing fiduciary duties, or you have fiduciary duties to multiple organizations. And so sometimes it's somewhat counterintuitive to think of it this way, but if you have like a grant making organization that is making grants to fund programs in a certain area, and then you also sit on the board of an organization that's applying for grants, that presents a conflict. And so if the director that sits on the board that's going to be providing the grant, so generally disclose the conflict and not approve any financial transaction. And again, it may result in great news for both organizations, but it's just a best practice to go ahead and disclose and recuse in those scenarios. Next slide, please. While the board is the primary decision-making body for the organization and is charged with oversight over the organization, in most cases, directors or volunteers. Sometimes you'll have a staff person who serves on the board, but typically they're volunteers and they're not at the organization every day. And so they will hire staff to oversee the day-to-day operations of the organization. And oftentimes they'll hire somebody like an executive director or someone with a similar title who serves as the chief executive officer for the organization. And that person is generally authorized by the board to oversee the day-to-day operations. The board can't be bogged down in every minor decision. So they a lot of times will have authority to hire staff and certain HR functions. I think it's important to keep in mind that while that executive director runs the organization day to day and is really the boots on the ground and knows what's going on under the act, certain key decisions will require board approval. So if you're going to amend your articles and bylaws, if you're going to approve the sale of substantially all your assets, anything involving a merger, anything like that will require board approval. And even if technically board approval is not required, it's often a good idea to get the board to back you so that the board is informed, first of all, of what's going on with the organization, and also because it helps support the executive staff if they have the backing of their board so I would say key transactions. A lot of times there'll be spending thresholds for which the executive director can spend up to, or they can enter into contracts, let's say maybe $50,000 or less, but anything over $50,000 will require board approval or two signatures or something like that, so that there's some accountability. Next slide. D&O insurance. Jane's content is really going to focus on this, and I don't want to steal her thunder too much, but I think it's helpful to keep in mind a lot of times directors want to make sure that the organization has directors and officers insurance before they will serve on a board. It's usually relatively inexpensive to have, and even if, and we're going to look in the next segment on some volunteer protections that are provided in statute that help volunteers ensure that they're not liable for actions taken when they're acting as a volunteer on behalf of the organization. Nonetheless, there are often costs associated with defending such claims to get to the resolution that there was, that they're not liable. And directors and officers insurance is really important in defending those such claims. So just making sure that the organization maintains that D&O insurance. And with that, I will hand it over to Jane.
Good afternoon, everyone. I am pleased to speak with you today about risk management and mitigation. I've been listening to the comments from Joe and Heather, and I've realized that I think I have the heavy side here, the sort of the bring us down portion of the presentation. But what I'd like to do today is try to bring some clarity to some issues that may be of concern to the organization so that you can better manage risk and be confident in your way of proceeding through risky situations. Can we just switch to the next slide? Okay, so what I wanted to start with is just to ask what liability risks exist for your organization. And this is something that I think is worthwhile for, those of you that are managing risk to just sit down and think about. It's impossible, of course, to create an exhaustive list, and it's not going to be the same for every organization. But in general, some of the issues that I think are, likely risk situations for youth serving organizations are just general negligence claims, sexual abuse of a minor claims, fraud. That is an issue that we are seeing more and more across, volunteer-led organizations, unfortunately. And then reputational risk, which is a little bit of a different liability. That's not, that's not a legal liability, but it really does, I think, have a tendency to create harm to your bottom line in the sense that it can hurt fundraising. So I think, it's worthwhile to set aside some time just to look at what risks your organization is facing. But these are some of the topics that we're going to run through here in the next few slides. Next slide. Okay. First of all, best practices. Just wanted to make a list of policies and procedures that are viewed as best practices across the industry. Not all of these, may apply, but I think most of them likely will. First of all, having some sort of child protection policy, having a clear statement of, what efforts you are making to keep children, within your organization safe. Doing a risk assessment or auditing your risk. That goes along with, what I was initially proposing, that you set aside some time to think about what special risks you may face as an organization. Doing background checks for your volunteers and your employees, particularly those that are interfacing with youth. Developing a code of conduct for your employees, volunteers, your board members. Investigating partners and locations. Part of managing risk is not only managing what's going on within your own organization, but also to the extent that you are hosting events off-site or partnering with other organizations, making sure that you have done some diligence with respect to their adherence to good practices and being aware of, any special risks that may be involved in those scenarios. Conducting training for your employees and your volunteers. Having clear reporting channels, and we're going to talk a little bit more about child abuse and neglect reporting in just a moment. And then having strong board policies. Conflict of interest is, one that Heather was just speaking to. Ethics policies, document retention policies, anything where you want to have a standard of practice and make sure that your board members are aware of and committed to those standards can be, wise to establish upfront. Next slide. Okay. What statutory obligations do you have? Well, you have to follow all federal, state, and local laws, right? So there's no way, I think, to answer this question, with particularity as to every organization. But there are a few special issues to watch out for that involve youth. One is the reporting obligations. Are you a mandatory reporter, and how do you report? We're going to go through that here in detail. And then this is, maybe a little bit of an aside, but to the extent you find yourself dealing with any situation involving sexual abuse of a minor, making sure that you do not happen to take possession of any evidence of any sexual abuse that would constitute child pornography, because that is in and of itself a crime. There was a situation that arose about 7 or 8 years ago here in Indianapolis where a prominent attorney in town did take possession of some materials that were deemed to constitute child pornography, and that, you know, resulted in a disciplinary investigation and a lot of you know, a lot of attention that's best avoided by simply, you know, alerting the authorities and turning anything over without actually taking possession of it. Next slide. Okay. Indiana's mandatory reporting law. We are a mandatory reporting state. I suspect that all of you are aware of this, but we'll just run through the details to make sure. Anyone in Indiana who has reason to believe that a child has been a victim of abuse or neglect shall make a report. So who has to report? It's anyone. What do you have to report? It's reason to believe that a child is a victim of abuse or neglect. So it's not certainty. It's not absolute knowledge. It is reason to believe, which is, you know, a significantly lower standard than absolute knowledge or confidence. Where do you have to report? Here in Indiana. When do you have to report? Immediately, when you have reason to believe that a child is a victim of abuse or neglect. Why? Of course, it's to protect our children. And how? We want to make a report, written or oral, to the Indiana Department of Child Services or law enforcement. In situations where, you know, we have counseled clients with respect to reporting obligations, our advice is typically to immediately make an oral report and then to follow that up with a written report that confirms that you made the oral report, who you spoke with, the content of the discussion, and any instructions that you received, so that you memorialize that both for the authority that you've reported to, you know, and for your own records. Next slide. Okay, again, it doesn't require actual knowledge. I just want to put a real fine point on that. Only a reason to believe. When you look at what the statute covers, it's acts or omissions by a person against a child, such as if the child is a victim of any crime committed by or permitted by a parent or guardian, as well as conduct that would not rise to the level of a crime. It includes endangering the child, abandoning or cruelly confining the child, depriving the child of necessary support, or depriving the child of education. Next slide. There's a case that was decided about 10 years ago now, Smith v. State, which involved a principal's obligation to report an act of abuse that occurred within the school. And that case, you know, if you're interested in reading it, just to get a better sense of this, it goes through a lot of the rationale behind the law's stated purpose, and also, you know, why the law is what it is. I'm not going to reread everything that's on the slide, but you get the sense there are, you know, really well-intentioned policy reasons behind Indiana's mandatory reporting requirement. And of note, that case considered whether a 4-hour delay in reporting was a problem, and concluded that it was, that did not constitute an immediate report to authorities. And so the conviction in that case was upheld. Next slide. Okay, here's the nuts and bolts of it. If you need to make a mandatory report of child abuse, you can make your report either to the Indiana Department of Child Services, and the hotline number is there, or law enforcement, and that would be done just by calling 911. Again, that's a statutory requirement. Next slide. Okay, One more slide on this rather heavy topic. Consequences for failure to report. It is currently a Class B misdemeanor. There is legislation that is moving through the General Assembly as we speak that would increase the penalty to a Class A misdemeanor, which would increase both the jail time and the monetary fine. If you're concerned, if you're ever in a situation and you feel like you're, in a dilemma as to whether you should report or, you don't have a good enough reason to believe that there's been child abuse, you should know that the law presumes that reports are made in good faith. Individuals who make reports are immune from liability, even if the report is ultimately classified as unsubstantiated. The only exceptions for this is if the report is, intentionally false or the product of gross negligence or willful or wanton conduct. So essentially, if you were trying to get back at someone and you didn't have any good faith basis to believe the report. And then finally, a statutory statement that private or public institutions may not establish any policy that restricts or delays the duty of an employee or individual to report under this chapter. And the really, I think, practical takeaway from that is that all of your employees should be instructed that they are mandatory reporters and that they have the obligation, if they have a good faith, reason to believe that there has been child abuse or neglect, to report that. It should not be the policy of the organization to have the report flow up within the organization. Anyone who is aware of abuse has the obligation to report it immediately. Next slide. Okay, this is actually the final slide. Again, just, to put an exclamation mark here, don't wait to investigate. Don't call on anyone else. Waiting to report is a violation. And, go ahead and make the report upon having reason to believe. Next slide. All right, this gets a little bit more sunny. And I'm going to turn this over to Heather to talk about what statutory protections we have for volunteers.
Yes. So, and this is specific to volunteers, so not staff, but people who are actually volunteering their time on behalf of the organization. And there are sort of two statutory constructs that are intended to help protect volunteers of a nonprofit organization. There's a federal statute, which is the Volunteer Protection Act. And so, if you're acting within the scope of your responsibilities, if there's, and if you are supposed to be licensed to carry out that activities, if you have that license, and something happens, you generally would not be found liable under the Volunteer Protection Act. There are exceptions, just similar to what Jane was just talking about. If there's willful or criminal misconduct, a hate crime or sex offense, or if you're under the influence of drugs and alcohol. Similarly, the Indiana Code includes also volunteer protection for volunteers, that if a volunteer of a nonprofit, and I think the Indiana Code actually carves out, like, that's exempt from tax, like a 501c3 or similar organization that exercises reasonable care is immune from civil liability arising out of the performance of duties. So again, those protections are intended to protect volunteers, because we want volunteers to willingly serve our organizations, and we know that they're so important to the activities of the organization. So these protections are intended to encourage volunteers and give them some comfort as they serve. I think one thing that's helpful to keep in mind, and this just goes back to that, the D&O insurance and just insurance in general, is that even if you're ultimately found under one of these acts to not be liable, a volunteer is found not to be liable, there's still costs sometimes in defending that claim. And even if it's just to point to these statutes and whatnot. So insurance is still an important thing to have, but ultimately it's also helpful to know that these statutory protections exist. I think Jane is back on.
Okay, next slide. All right. What about insurance? I'm sure this is everyone's favorite topic. Here are some things to think about with respect to insurance for the organization. And I know Heather and Joe have talked a little bit about the D&O policy. First of all, who is responsible within the organization for obtaining insurance? What amount of insurance is appropriate for your organization? Who is covered by your insurance policy? Are there any exclusions to coverage? And what are they? And are they really workable? Do they actually, in some ways, invalidate the policy that you believe that you have? You want to make sure that your activities are covered to the maximum extent possible and that you believe them to be covered. And then this is a tidbit from experiences in the past. What should you do with your old policies? Absolutely keep them. There is a difference between there are two different forms of insurance policies. One is claims made, one is occurrence based. In a claims made policy, the policy that you have in effect at the time that the claim is made is the policy that responds. An occurrence based policy, whenever the act of of liability is alleged to have occurred, the time period for that, the insurance policy that was in effect at that time is the responding policy. So, occasionally there are claims that are made that can be decades old. Obviously, we have statutes of limitations and, other affirmative defenses like laches that sometimes bar claims like that. But nonetheless, sometimes decade-old claims can be made. And it can be, sometimes a challenge to locate the insurance policy that would provide defense and coverage for those situations and those allegations. So have a really good, record storage system for your insurance policies and keep them. If you know that they are claims made policies, this is a little bit less, less important, but as a general rule, I think the safest thing is to, find a good electronic storage system or a good filing cabinet and just keep them. Next slide. Okay, different types of coverages that are out there. These are, I would put these on the list of things that you want to review with your broker. What kinds of coverage do you have on your policy? Is it adequate? Are there exclusions from coverage? Again, I don't want to read through the list that's on the slide, but there's a variety of coverages and not all policies have all coverages. You need to understand what your policy includes and make sure, again, not only what the coverages are, but if there are any relevant exclusions to the coverage. I think this is, frankly, a topic that would be good for certainly review with your broker to the extent your organization works with an insurance agent, or having a board member who is experienced with various forms of insurance, giving this a good look on a fairly regular basis. Next slide. Okay, just a couple words about waivers and releases. Is there a difference? Yes, technically, but no, practically. Waivers give up a right, releases transfer rights. For the most part, as waivers and releases are written, they are essentially interchangeable, and liability is usually transferred or, given up by the participating individual in favor of the sponsoring organization. Who needs to sign your waivers and releases? Well, because we're, working with youth who are minors and not able to legally contract, you should have parents sign as well as the minor. Special enforceability considerations. I'm going to turn that over to Heather in just a second, but I'm just going to briefly just note on special activities and venues. If you're working with, a trampoline park, for instance, taking your youth to, a special event like that, they likely have their own release form. And you want to look to see whether there's liability that is transferred from a venue to your organization. And I'll let Heather talk about special enforceability.
Just one comment, because I know we want to leave time for questions, but just one comment on the releases. We used to say that both parents should sign releases and waivers, but as a parent, I know practically that is just really difficult. So what we have sort of moved towards in most cases is that one parent can sign, but we generally include some type of language which says that the parent who's signing is sort of authorized to bind other parents or in the minor, who would have an interest. So I think that's maybe just one thing to keep in mind, that if you're going to have one parent sign it, it's helpful to include language like that.
Okay, next slide. Okay, what should your releases include? Your releases should release all claims, except maybe gross negligence and willful misconduct, because it's questionable under Indiana law as to whether those kinds of acts can be released or whether that would be inconsistent with Indiana public policy. You should look through your release to see what it says with respect to indemnification. It may be that you are asking your releasees to indemnify the organization for either all or release claims. And then, we have begun advising people to include a photo release so that you can use images for special purposes and marketing and promotional materials, including social media. And it could be a situation if you have folks who are not willing to sign a photo release or a release of liability, that the consequences that, you are not able to allow them to participate in the event. Again, those are issues that you'd want to work through on a individual and specific basis. And I just have a friendly PSA. I think particularly when you're talking about waivers and releases, and if you're engaging in any, sort of high risk activity, that's a good time to have your lawyer look over the form release that you are using. Next slide. Very briefly, what if you get sued? Call your lawyer, call your insurance carrier. Don't communicate in writing because anything communicated in writing at that point is going to be discoverable, and you want to avoid creating any kind of evidence that would be inadvertently harmful to the organization. Don't destroy any documents or delete any electronic messages from the point at which you have reason to believe that you might get sued, or that you are sued. Certainly, you have an obligation to preserve documents, and spoliation, which is the claim that's sometimes made if records gets destroyed, is a very difficult claim to deal with, and you want to avoid that. And then I'd recommend preparing a media statement, even if it's only that the organization doesn't comment, so that you have a message that's prepared for your staff to deliver. And with that, I think we're ready to turn it over for questions.
All right. If you have any questions, please drop them in the Q&A or even in the chat. All right, we have one question. Are you seeing organizations update any policies to include any new risk with AI?
I can speak to this. I just helped I just had an organization. I think we are just sort of on the forefront of seeing this, and I've had a couple of organizations ask recently about AI policies, and we have drafted a couple specifically saying, like, asking board members not to use AI, not to put any sort of sensitive information into AI. So even sometimes there's there's note taker and things like that, but they're asking board members not to use that because they fear that the personal information or the sensitive information of the organization could be publicly available. So I think it's something that we're just starting to see, and organizations starting to be concerned about how their information could be be made public through the use of AI, although also recognizing that AI can be really helpful too.
Okay, a couple more questions coming through. What is the difference between a release and waiver?
I'll take that one. Again, it's really more technical than practical. A release, if I sign a release, I say I release my rights in some way, usually a right to sue for an act of negligence. excuse me, I just misspoke. That's a waiver. I waive my right to sue. If it's a release, you're technically releasing it to another party. And usually in that scenario, you're releasing it to the hosting organization. Again, as those terms are used, it's essentially interchangeable, unless you have a situation where you're releasing your rights to a third individual.
Thank you so much. Unfortunately, we do have to transition out. I know that a lot of people are working, and so we just want to make sure that in interest of time, we are transitioning out here. If you do have any additional questions, this webinar will be recorded and sent to you all. Sorry, technical difficulties. All right, there we go. Let's get back on here. Thank you all for attending this webinar. We are so grateful for you joining. We have our upcoming webinar, the part 2 of this. So make sure that you're registering. There is a link in the webinar chat. Legal Basics for Youth Serving Organizations, part 2 on March the 12th. So make sure that you're registering for that. And if you want to follow IYI, we have our weekly update newsletter, and it has all the information, different webinars, different youth worker cafes that you all can get involved in and be up to date with great information, just like this one that you've received. Thank you all so much for attending, and we are so grateful for youth workers like you doing the work that you do. Have a great rest of your day. Bye.